All right. The defendant's in the courtroom. Ladies and gentlemen, the jury has knocked on their door and announced that they have a verdict. Before I bring them in, I want to remind everyone of the conduct requirements, although I really think this is not necessary with this group. But remember, the jury is entitled to their verdict, and it is entitled to respect, and there's oftentimes people that have opinions and thoughts about them and verdicts, and if you find yourself to be perhaps that person that may not be comfortable with a verdict that they find contrary to their point of view, then it would be appropriate to step out and not be in the courtroom, because I won't allow anyone to express any opinions of the work that the jury has done. They've been studious, they've been dedicated, they've worked very, very, very hard, and the taking on of this responsibility as a citizen, when it's certainly nothing that anyone volunteers for, and when you're pulled out of your private life and serve on a jury, then that work, when they've worked so hard, is deserving of great respect. And I know that everyone in this courtroom feels the same way and will adhere to those conduct requirements. With that, please bring in the jury.
Let's all rise for the jury, please.
Members of the jury, it's good to see you again. My understanding is that the jury has arrived at a verdict. Would the foreperson please stand? Mr. M., is that correct? Have you in fact arrived at a verdict?
Yes, Judge.
If you will hand it to the bailiff will bring the verdict to me for my review. The verdict is in proper form to be received by the court. At this time, I'm going to ask the clerk to publish the verdict. Thank you, Mr. Phillips.
In the Superior Court of Cobb County, State of Georgia versus Justin Ross Harris, defendant, case number 14-9-3124, verdict form. We, the jury, find as follows: count one, malice murder. As to count one, we find the defendant guilty. This 14th day of November 2016, killed only four-person. Count two, felony murder. As to count two, we find the defendant guilty. This 14th day of November 2014, held employment four-person. Count three, felony murder. As to count three, found the defendant guilty. This 14th day of November 2016, CN four-person. Count four, cruelty to children in the first degree. As to count four, we found the defendant guilty. This 14th day of November 2016, CN four-person. Count five, cruelty to children in the second degree. As to count five, we found the defendant guilty. This 14th day of November 2016, CN four-person. Count six, criminal intent to commit a felony, to wit, sexual exploitation of children. As to count six, we found the defendant guilty. This 14th day of November 2016, CN four-person. Count seven, dissemination of harmful materials to minors. As to count seven, we found the defendant guilty. This 14th day of November 2016, CN four-person. Count eight, dissemination of harmful materials to minors. As to count eight, we found the defendant guilty. This 14th day of November 2016, CN four-person.
Counsel approached to review the verdict. What I said to the jury, I sincerely mean, gentlemen. You all have tried a really good case. You've worked hard, and it's been well developed. And I need to say that to you all as well. Sentencing hearing, what says the state?
The state will be ready whenever, Your Honor. We do have to, I think, under the law, notify next of kin and victim and the latter counts of the indictment for when sentencing is going to be set. But we'll try to do that as soon as we can, as soon as Your Honor sets a date. We're ready whenever.
Defense?
We're ready now.
Well, they have to notify people. I don't see that as happening. Have you got the calendar? How long do you anticipate the sentencing hearing to be?
From the state's position, probably no more than 15, 20 minutes.
And from the defense, do you have an estimation?
We will be putting up no evidence, nor making any argument.
Let's set it for December the 5th at 1:30 in my courtroom in Cobb County. All right, we need to advise the defendant of his appellate rights. Mr. Kilgore, I don't anticipate you've had an opportunity to discuss that with your client.
They've been discussed at great length.
Then to your credit, do you want to make a predicate statement of some sort?
I do
for me?
not.
Well, what have you, well, okay, then what have you advised him of?
That if he's convicted, he has the right to appeal, and we'll be taking care of that.
You're going to take care of that?
Yes, ma'am.
Okay, all right. Well, then, Mr. Harris, your counsel has advised me that y'all have discussed appellate issues at length, and that they are going to file the notices of appeal in a timely manner. Generally, that's going to be within 30 days, at least kind of a blanket notice of appeal to be fleshed out at a later time. Would that be consistent with what you advised him, Mr.
That's,
Kilgore?
we went into a good bit more detail, but he's aware of those rights that he has, and he's aware that we're going to be handling those in the proper fashion, Judge.
Well, the thing that's important for me to tell Mr. Harris is that he's got 30 days to file a notice of appeal, and it can be very blanket and pro forma, but the 30 days is the deadline, and that's what needs to be said by the court. Mr. Harris, do you understand that?
Yes, ma'am.
Thank you. All right, is there anything else for the state?
No, Your Honor.
Is there anything else for the defense?
Not at this time, Judge.